Hi. Okay. The first thing I want to go through is the notice of liability that was issued to Dave Jones of North Yorkshire Police, which is this one page, and we're going to zoom in to be able to read it. Okay, first thing, it's a notice of liability for unlawful actions in the future. It was posted, it actually was shipped by recorded delivery on the 4th day of November 2017 to David Jones, the man, i.e. the human, and acting as Chief Constable of North Yorkshire Police. It's numbered page 1 of 16, so it's a 16-page notice. The first part of the notice is how contracts work, and it states quite clearly: silence is acquiescence, agreement and dishonour. And then first point there under is all are equal under the law, and then it's referenced where it is. We all understand this as fact. No one is above the law. And then again it goes on. This is from commas: by the law of nations ought to be common, not to be converted into a monopoly and the private gain of the few. Again, we all know that, and we believe that no one's above the law and all are equal under the law. However, what's less known is, in commas, truth is sovereign, and truth is expressed by means of an affidavit. Now, we've all been in endless discussions where they just go round and round, where people move off the point and don't answer direct questions, and that's why a lot of arguments just become arguments, because it's emotion, it's not based on truth. And this is a method which is used in commercial law, the law of the sea, whereby the truth can be established. This contract is self-executing upon your next unlawful action. So why do I say that? Because in commercial law, an unrebutted affidavit stands as the truth in commas. He who does not deny admits. An unrebutted affidavit becomes the judgment in commas. And again, it's the reference: any proceedings in a court, tribunal or arbitration forum consist of a contest or duel of commercial affidavits, wherein the points remaining unrebutted in the end stand as truth and the matter to which the judgment of the law is applied. So essentially what this is saying is, in order to establish the truth, okay, one person can lay a claim on another, and the claim goes through the statement of facts to establish the truth. The other party is innocent until proven guilty, and hence there's the duel. It comes from the old days of sword fighting, last man standing. That was the law of the jungle, might is right. However, to try and make it more in truth, based in truth, it's in the form of an affidavit. The claimant, in this case me, I've made my affidavit, and David Jones and the rest of the named parties to whom this notice is addressed need to rebut the truth. They are innocent until proven guilty, and so any truths that they can not rebut will stand as the judgment. And that's the role of the judge, which is why you get no justice, because it's not actually about principles, it's about affidavits of truth, nothing to do with the law. It's based in truth. So this this notice is to David Jones, who is an agent of North Yorkshire Police, acting as the Chief Constable of North Yorkshire Police, and the human. So it's addressing him as a human, which is under the law, and as an agent, which is under statutory law. 2. it's also addressed to all principals and agents of North Yorkshire Police and as the humans. Therefore, all principals go up to the head of government. Anybody that is where North Yorkshire Police derive any authority from and hence jurisdiction, and the agents of North Yorkshire Police. So this is all principals and all agents of North Yorkshire Police. So this means this notice is applicable to everybody in North Yorkshire Police, plus the principals above in government. And thirdly, it's to all agents of those principals of North Yorkshire Police. Okay, so that's the principals in 2, and as the humans. So basically it goes all the way to the top as principals of North Yorkshire Police, and all of those principals agents all the way back down, and therefore it goes to the highest human in government and back down to the lowest. Here and after in this notice they're called the liabilities, or the respondents. It's from me, Mark Horn, as the human, claiming all rights and duties. This is often written as without prejudice, or in the legal system it's without prejudice. This is what it actually means. I claim all my human rights and duties of being a human, with retroactive effect. Basically, where I've made mistakes in the past, because they were unknowing, they are included into my rights in that, which in the legal profession basically they use the term nunc pro tunc, which basically gives them no liability of past mistakes. I'm hereinafter the claimant. So this, the 4th day of November 2017, and it was signed and witnessed, and I'll attach the signed and witnessed one. Now, this notice to respondents and liabilities, it's not my intention to harass, intimidate, offend, conspire, blackmail or coerce, or cause anxiety, alarm or distress. This document and the attachments are presented with honourable and peaceful intentions, and are expressly for the benefit to provide you with due process and a good faith opportunity to state a verified claim. This is, I'm a peaceful man. I do not look for violence. However, violence was carried out upon me where I was unlawfully detained, i.e. I was a slave. If I didn't do what they said, they were going to use force on me. And there's plenty of evidence which we'll come to in the statement of facts, which will be the next video. However, as an introduction to the statement of facts, i.e. the establishment of the truth, what is a fact? It's knowledge, as a noun, knowledge or information based on real occurrences, an account based on fact, something demonstrated to exist or known to have existed, a real occurrence, an event. The legal definition according to Black's Law, Dictionary 4th edition, a state of things that is an existence or a motion, that is an event. However, it's all about perceptions, and there's numerous pictures and things showing that we may all perceive things slightly differently. Now, proof, because it needs to be proven beyond a shadow of a doubt that my statement of facts are correct. And again, this shows that facts are subjective based on our perceptions of what we believe, which is derived from our life experience. So, proof, the evidence or argument that compels the mind to accept an assertion as true, hence a fact. The validation of a proposition by application of specified rules, as of induction or deduction, to presumption axioms, and sequentially derived conclusions. And as I've said, facts are subjective, depends on your experience and your view, and this is confirmed in the legal definition, again from Black's Law Dictionary, 4th edition, to the establishment of fact by evidence. So there's no doubt facts are based on people's perceptions. So what types of proof are there? Visible to all through the same method of investigation, i.e. a very scientific approach. So what types of evidence are there? A statement of fact is by first-hand witness. Thereafter it's hearsay. So for example, your birth certificate, is it a fact or is that hearsay? Do you have any recollection of witnessing what got written on your birth certificate? No, therefore it's not a fact. It is hearsay. Okay, so next video segment is going to be on the statement of facts, going through point by point. Thanks. Bye.